The next matter to come before us this afternoon is Matthew and Katherine Snyder versus Old World Classics, LLC. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. Please let me know when you get started if you'd like to reserve any time for rebuttal. I'm keeping track of the clock this afternoon and can let you know the passage of time. The arguments are being both live streamed and recorded and will be hosted on the court's YouTube channel. For that reason, please refrain from using the names of any victims or minors. I don't think that's a problem necessarily in this case. However, we'd like to make that admonishment so everyone is aware. The judges have read your briefs. We're ready to proceed when you are.
Thank you. May it please the court, my name is Matt Snyder, and I am appearing pro se on behalf of the appellants, which includes me and my wife, Kate Snyder. With the court's permission, I would request to reserve 5 minutes of time for rebuttal. We, the Snyders, respectfully request that the court reverse the trial court's decision so that the case against the appellee, Old World Classics, can proceed in open court rather than being hidden behind the closed doors of private arbitration. It is only because of Old World's deceit that this appeal even exists. If my wife and I would have known the truth about Old World, we never would have agreed to an arbitration provision. Old World's deceit induced us to agree to an arbitration provision on the belief that Old World was run by ownership that did not have an alarming litigation history, which we later discovered included claims of fraud that left creditors shortchanged and forced homeowners to defend lawsuits against suppliers after the owner declared bankruptcy. Further yet, Old World's deceit has denied the public, including my wife and me, an opportunity to reasonably discover the alarming litigation history because of the wrongdoing that has remained hidden from public view. An absent reversal, Old World's continued reliance upon private arbitration would mean that future consumers in Ohio would be deprived of access to Old World's history as they consider the most expensive and important purchase they likely will ever make. It is high time that Old World's unlawful actions be judged once and for all in a public forum. If this case is tried in open court, Old World will be subject to the rules of discovery so that it ultimately can be judged by a jury of its peers. The Ohio Attorney General's office and local media will have a better opportunity to take notice. As consumers, my wife and I will be afforded all of the rights and remedies of the Home Construction Service Suppliers Act, aka the HCSSA. Even Old World will benefit by having an opportunity to public defend itself. Simply put, a public trial is to the benefit of all concerned. On the other hand, if this case is decided in private arbitration, the only one to benefit will be Old World. The arbitrator will be explicitly tasked with conducting a secretive and expeditious proceeding. Such a proceeding may exclude non-contract claims and thereby undo the protections afforded by the HCSSA. The arbitrator would not even be required to issue findings of facts and conclusions of law. All the while, the arbitration costs would remain open-ended, and the general public would remain none the wiser of Old World's unlawful practices. So the crossroads at which the court finds itself is clear: a public trial versus private arbitration. The facts in this case and the law of Ohio manifestly point in the direction of a public trial. Although mutually exclusive, the two issues presented for review dovetail nicely together. Old World's fraudulent inducement, standing alone, voids the arbitration provision, and it is those fraudulent acts by Old World that definitively tip the scales in favor of voiding the arbitration provision on public policy grounds as well. Now, turning to the two issues on appeal. First, the fraudulent inducement of the arbitration provision. Both sides agree that the Ohio Supreme Court precedent in ABM Farms controls in this case, which means that in order to prevail, a defendant must have made a knowing material misrepresentation with the intent of inducing the plaintiffs, and the plaintiff relied upon that misrepresentation to its detriment. The record in this case is replete with such evidence. The complaint has been verified, and the record also includes sworn affidavits and 19 evidentiary exhibits that total over 300 pages. All of that evidence shows that Old World misrepresented that its ownership had a troubled history of litigation. Now, specifically, those two misrepresentations at issue as far as the arbitration clause is concerned. One, Old World misrepresented that its owner, Andrew Eggman, had not been the owner of the litigation-plagued company known as Old World Classics by Phil Eggman, which we have stylized in our brief as Old World predecessor. And two, Old World misrepresented that Old World and its ownership only had been involved in one arbitration. The genesis of these representations occurred at an in-person meeting held back in October of 2020 between myself, my wife, and Jim Yesbeck on behalf of Old World. Throughout this case, Mr. Yesbeck notably has remained silent as to what occurred at that meeting. On the other hand, my wife and I both have submitted at the trial court affidavits as to what was discussed, in which we attested under oath in affidavit that those representations were made. In addition, my contemporaneously notes that I took during the course of that in-person meeting show, in fact, that those representations were made to us at that meeting in inducing us to sign and agree to the arbitration provision. So the record is clear without any dispute that those representations were made. Now, as far as the fact that those representations were in fact misrepresentations, that occurred post-contract when we discovered that Mr. Eggman had a very long and storied ownership history with Old World predecessor, which was a very troubled and litigation-plagued company, again, by a very similar name. As the sole owner of that company, Mr. Eggman was accused of himself issuing false affidavits. The company itself was issued in two separate cases of committing fraud. Mr. Eggman also appeared pro se after letting his attorney go in that case. And the only way we were able to find out that the affidavit that Mr. Eggman filed in this case with the trial court, in which he stated incorrectly that the company was his father's company, was we located a bankruptcy petition in which 88 pages we perused to discover that Mr. Eggman represented to the bankruptcy court that he, in fact, was the sole owner of Old World predecessor. Old World's misdirection continues even in the public face by the fact that Mr. Eggman's LinkedIn profile doesn't even mention any career history before the current iteration of Old World. Even putting aside Mr. Eggman and Old World predecessor, Old World Classics LLC, in fact, has been sued as well, again, which was not disclosed to my wife and me when we were induced into the arbitration clause. Old World was sued for breach of contract by the former director of sales and conceptual design for Old World, which Old World in its own brief admitted occurred, which occurred on page 12 of their brief. So the evidence is quite clear. Again, overwhelming evidence of fraud in the inducement. Now, as far as the second issue on appeal, the public policy, inequity in particular, as the court is aware, my wife and I, as appellants, relied fairly heavily on the case of Eagle versus Fred Martin out of the 9th District. That case remains good law. As we noted in our briefs, it was filed or cited and quoted with approval by the Ohio Supreme Court. Old World responded in its reply with a subsequent case, Tomovic v. USA Waterproofing. Unfortunately for Old World's position, Tomovic did not overturn Eagle, but there's simpatico in that Tomovic did not argue or did not hold for a cross-the-board overturning of arbitration provisions, but both cases together read as if the individual facts of the arbitration provision must be assessed under public policy grounds. And as we stated in our reply brief, all of the considerations that the Eagle court made during its overturning of the arbitration provisions are present, if not worse, factually than our case. On top of which, in Eagle, there wasn't even colorable allegations of fraud against the defendant in that case. So the totality of the public policy argument also does favor reversal of the trial court's decision.
Mr. Snyder, what about the case Schillingberg versus Turtle Creek Assets? That requires the court to hold an evidentiary oral hearing. Wouldn't the proper remedy in this case be to remand it back to the trial court for it to have an oral hearing, since our precedent is so strong that there must be an oral hearing when there's a motion to compel arbitration?
Well, I think Schillingberg is distinguishable in this case. That case, Schillingberg cited that it's especially required, it being a hearing, is in the scope of the arbitration agreement is contested. And Schillingberg relied upon Boggs as a prior case, which also was contesting the scope of an arbitration provision. Eagle, on the other hand, on paragraph 22 of that decision, addressed this very issue, and it found it compelling that the weight of evidence had already been briefed, though a oral hearing was not held. It nonetheless moved forward with a substantive decision based on the fact that there was plenty of evidence in the record in that case, which is also, again, present in our case. So I think for the facts of this case on a public policy decision, as well as fraud, which again, Schillingberg and Krakoa, which was cited in Schillingberg and Boggs, none of those cases rose to the level of seriousness as far as the arbitration provision at issue. These are issues, matters of law that can be decided and should be decided. And quite frankly, an oral hearing would not add anything that would affect or impact the decision-making process for this court, in my opinion.
And counsel, I need to let you know, I'm sorry, Mr. Snyder, I need to let you know you are just now reaching into that 5 minutes of rebuttal time. You can reserve or continue as you wish. I wanted to let you know that.
Unless the court has any other specific questions, I'd be more than happy. Otherwise, I'll reserve the rest or remainder of my time.
Seeing none, looks like you're going to reserve about 4 minutes and 55 seconds.
Thank you.
Attorney Jones?
Thank you, Your Honor. Good afternoon. My name is Aaron Jones. I'm representing the appellee in this matter. I would like to start with Judge Lanziger's reference to the Schillingberg decision. As noted in our briefs, it is our position that this court should apply the case law of the 4th and the 8th districts, which does not require an oral hearing in the event that neither party requests one. And to be clear, we are not requesting an oral hearing on this matter, just as Mr. Snyder is not. So our request would be that the court consider that fact in making this determination. But I certainly do understand that the court—
Why should we follow the 8th district when we have a 9th district case on point?
I understand, Your Honor. I certainly understand the precedent there, and that this court will very likely follow its own precedent. That I think I noted in my brief and in a prior motion to stay pending the Supreme Court's AJZ hauling case. And as I guess an additional note on that, the Supreme Court did issue a ruling, I think 20 days ago now in that case, and they ordered arbitration based on collateral estoppel and did not resolve the conflict that's here. This court has on 2 separate occasions certified this as a conflict to the Supreme Court now, I believe. It certainly did in Schillingberg, and I believe it did in a second instance as well. And on neither of those occasions did the Supreme Court have the opportunity to resolve the conflict. So, I mean, it is my expectation coming here that this court will follow its own precedent. But just for the record and for the sake of argument and to preserve the issue, it is our position that the 4th and the 8th district are the correct approach there, and that there should not be a requirement for an oral hearing. But I certainly don't mean any disrespect by that. I understand your precedent. So I won't touch on that any further unless the court, prefers for me to address that in further detail. As far as the merits of Mr. Snyder's appeal, the first issue that he talked about was kind of a public policy argument. And I would say that the law disagrees with his position. Both state and federal law strongly favor arbitration. So the fact that that is not a public trial should not matter. The law says that courts are to favor arbitration. We have what I believe is a very much enforceable arbitration provision at issue in this case. And based on state and federal law, the court should enforce that provision regardless of his public policy concerns. As far as the fraud arguments that he's presented, I noted in our brief that this should be an abuse of discretion review of the fraud claim. The only time that the Court of Appeals applies a de novo standard to a decision on a motion to stay and compel arbitration is where there is a discussion of unconscionability. And in his reply brief, Mr. Snyder points out that he is not making an unconscionability argument. So it is our position that this should be judged under an abuse of discretion standard, and that there is nothing in the trial court's decision, short though it might be, that would amount to an abuse of discretion. The court is not required to give a detailed analysis. It's required to make a decision. It stated that it had reviewed the arguments of the parties and the evidence presented, and that it believed that arbitration was the appropriate remedy here, or the appropriate decision. And I don't think that there's anything in the record that would amount to an abuse of discretion on that decision. So I think that the standard should be abuse of discretion rather than any kind of de novo standard. And under that standard, this court would not even need to consider the factual arguments that Mr. Snyder is presenting, because this court should defer to the trial court's decision on those factual issues. As far as the facts themselves, if this court does decide to consider them, even if it does, the actual facts show that this was not a fraudulently induced contract. Mr. Snyder and his wife are both licensed Ohio attorneys. While they claim that they're not business attorneys, while they claim that they're not, contract attorneys, at the end of the day, any attorney should be able to understand the basic principle that what you put in a written contract matters. At various points in the negotiation process here, they had provisions in this arbitration clause that stated reference to what they allege Mr. Jim Yazbek told them about prior litigation or arbitration or mediation that my client was involved in. There was a clause that said contractor states that it has not been involved in anything other than one arbitration in the last 5 years. So what they had put in there, what they had written in that contract as an initial draft, was that my client said in the last 5 years they have not been involved in any kind of arbitration or mediation. And quite frankly, that's true. The only other case that they pointed to, that the Snyders have pointed to, that my client was involved in, was a 2017 lawsuit with a former employee over an employment contract. It has absolutely nothing to do with construction or to Mr. Snyder's claims. The fact that my client was sued by an employee over an employment contract just should not be relevant to this court. And so in the last 5 years, it is absolutely factually accurate that they have not been sued, even if we assume that these were the same companies, this old world predecessor that Mr. Snyder referred to, even if we were to assume that it was the same company as the current one, which it is not, it's still, they haven't been sued in the last 5 years. And that is what Mr. Snyder himself wrote was the representation that was given. As an attorney, he should be held to the basic understanding that what he wrote in that contract matters. Now, he did end up amending that after my client provided an update saying it wasn't an actual arbitration, it was a mediation that they were involved in. And then instead of making that change as requested, he just removed that clause entirely. As far as the HCSSA, I believe that the argument for rescission specifically should not apply here. The law requires that for there to be rescission, there has to be no substantial change to the underlying contract. Mr. Snyder admits that an entire house was completed. I think the total cost was something like $1.4 million. This lawsuit is over roughly $32,000 out of a $1.4 million house. I don't think there is any rational argument that could be made that this was not a substantial change in the underlying contract for the construction of a house when an entire house was built. That to me is something that obviously is what the statute's meant to prevent. You can't just rescind a contract for the construction of a $1.4 million house and say, hey, we didn't get what we wanted over this $32,000 issue. So the whole contract's rescinded, we get all of our money back. That just is not a rational way to interpret that statute. And I don't think the law would allow for that type of rescission. As far as the ability to handle those claims in arbitration, there's nothing in the arbitration agreement or in the contract that would prevent the arbitrator from considering any statutory claims that Mr. Snyder would like to make. The contract specifies certain types and natures of damages that are permitted, but then it also goes on to state that those restrictions are only apply unless certain types of damages are not waivable under Ohio law. So Mr. Snyder can present any arguments that he might have to that front to the arbitrator that certain damages are not waivable under Ohio law, and the arbitrator can make that decision just as the arbitrator is charged to make any other legal decision in this case. There is nothing about this case that is unusual or that is something that an arbitrator could not handle. Mr. Snyder can present whatever he would like to the arbitrator, and they can make a reasoned decision. It also is not, there's not anything in the contract that would prevent the attorney general from learning about this dispute. So I don't think that the Eagle case cited by Mr. Snyder would apply. I think that Tomovich would apply in this situation. And it specifically stated that Eagle does not stand for the proposition that CSPA claims are not subject to arbitration. Obviously, there's no CSPA claim here, although it does contain similar language to the HCSSA. Tomovich affirmed an order compelling arbitration. And I think this court should as well, assuming that the court reaches the merits of the issues. I believe that arbitration should be affirmed and that the trial court's decision is not an abuse of discretion. If the court looks at this as an unconscionability standard, which, as I noted, would have a de novo standard of review, unconscionability can't apply here because Mr. Snyder has not made any argument regarding substantive unconscionability. The first instance in which he made any claim related to the cost of arbitration being an issue was in his reply appeal brief, which is not a situation where he can present new or additional evidence. So the court cannot consider that argument, I believe. So unconscionability cannot apply. And that is the only situation where the court would look at an order compelling arbitration under anything other than an abuse of discretion standard. Lastly, I believe that the peril evidence rule should apply to this case. I understand that ordinarily it would not apply to claims of fraud, but I think that this is a distinction given the very broad integration clause in the contract. I believe that covers any kind of prior discussions about, prior litigation of the owners or the entities involved, and that the peril evidence rule should preclude those claims from being raised now as essentially a breach of contract claim when they could have been included in the written agreement. As Mr. Snyder had initially drafted it, it was included in the written agreement, and he could have brought that as a breach of contract claim if he believed that there were additional lawsuits. It was his decision to remove that clause from the contract in the final version. If he had not done so, and he believed that there was some kind of, false representation, or that my client actually had been sued more times than what they had represented to him, then he could have brought that as a breach of contract claim. He could have said, look, here's a contract you signed saying that you haven't had any litigation or arbitration or mediation or whatever else in X number of years. And he could have then said, look, here's where you were sued. This was wrong. That's a breach of contract. He could have brought that claim. He personally chose, as an attorney representing himself, to remove that clause from the contract. At a certain point, an attorney writing a contract for themselves and negotiating it should be held to what they agree to and what they themselves write. Should not be heard to then complain that this is somehow they were so defrauded by this company that they couldn't even handle putting in things that they believe were material to the transaction. That's just not the standard that anyone should be held to, let alone an attorney. I think that's just a basic area of first year contract law is a 1L, that what you put in a contract matters. Mr. Snyder knows that. He's a competent attorney, even if he's not a contract attorney, and he can put a clause that matters to him in a contract if he thinks it matters. So I don't think that he should be heard to complain that it's fraud, that it did not appear in the contract when that was his decision to make. Unless there are any other questions, I don't believe that there's any other issues for me to cover on this. So I will end my argument there and let Mr. Snyder do his reply if there are no further questions.
Seeing none, thank you, counsel.
Thank you. Opposing side makes much of the fact that that email, the language included in that arbitration provision was taken out. First of all, the record doesn't reflect that I took it out. It's silent on who took it out, which party, whether it was me or Old World. But the problem with that argument is if anything had to be reduced to a contract, then the whole concept of fraud and the inducement wouldn't even exist. If everything had to be relied upon what was put in a contract, then the whole body of law of fraud and the inducement would basically be cast aside. What was proposed in the language was the positive representation that Old World made, which was that it and its ownership had only been in one arbitration over the past 5 years. That was the proposed language that I put. I, as the drafter of that language, did not see fit to include a positive as well as exclude a negative. For example, if somebody asked where I was born, I would say I was born in Ohio. I wouldn't say I was born in Ohio, but I was not born in Michigan. The positive affirmation excludes the negative. At least that's how I construct a sentence structure. Again, regardless of how I chose to draft that representation, my wife and I both have sworn affidavits in the record of the fact that this was discussed with Mr. Yazbek. We have my contemporaneously written hand notes from that meeting, which I wrote down the representations that were made. And it strains credibility that as a, quote, sophisticated attorney, that I took all the time to meet in person during a pandemic with Mr. Yazbek and that I supposedly was only concerned with the litigation of the LLC without a care in the world about its ownership history, its owner's litigation history, that I had no care whatsoever, that I didn't really care. I put my head in the sand. It strains credibility. A couple other points. Opposing side mentioned, or appellee mentioned, that this case is only a $32,000 case. It was pled in the complaint as in excess of $32,000 because that's the lien that was placed on this case. This is a six-figure case ultimately in damages. Unfortunately, we haven't gotten to the substance of the damages, but I just want to clear up the record on that. As well as fraud is not about sophistication. The U.S. Supreme Court in Field versus Mann said that only a cursory glance is required. Justifiable reliance is if the representation does not appear unreasonable on its face and if there's no reasonable doubt the veracity of the representation. Again, it was very clear the way that Jim Yesbeck sold this company was that Old World was Andrew Eggman with his friend, had no overlap, no history with this prior plagued, troubled company that was his father's company. He split them as if they were complete islands unto themselves. We bought it hook, line, and sinker. And as put in our brief, it took hours and hours of research, traveling to go to court dockets to pull physical case files to unwind the fact that Mr. Eggman was the sole owner of this predecessor company. And as I said in the brief, he stylized his name differently over the course of this time period. Sometimes it was Philip A. Eggman, it was Andrew Eggman, it was Andrew Eggman. In his bankruptcy petition, he spelled his first name incorrectly with 2 L's. So there's this history of trying to hide the ball from Ohio consumers as far as what actually is his history. It's not a company of the size where the CEO doesn't matter. He is the company ultimately, as far as his ability to run this small company, this small business, matters to me as an Ohio consumer on how he conducts his business. A history of fraud allegations is certainly apropos to any consumer, whether they're a sophisticated attorney or somebody who doesn't have the benefit of that education. But regardless, as the U.S. Supreme Court and as adopted by the subsequent Ohio courts have said, if you ask a defrauder point blank, you are justifiably allowed to rely upon that misrepresentation, especially when they have the superior knowledge to know their own history, where I can't readily find that information. Unless anyone on the court has any specific questions for me, I will rest as well.
Seeing none. Thank you both for your presentations today. Excuse me. Court will take the matter under advisement. We will issue a written decision in due course, which will be mailed to all parties to this appeal by the clerk of courts, as well as posted on the Ohio Supreme Court website.
Thank you.
Excuse me.
Thank you, Your Honor.